Thank you.
Dennis Albiano with California Pear Growers Association. We associate ourselves with the Mr. Brown and Mr. Blow's comments. Thank you.
Thank you. Any others? Seeing none, we'll go ahead and bring it back to the committee and have members ask questions. We'll start with Senator Jackson. I believe she had a question.
Yes, I'm not quite clear. Was the objection the last party that they would have to pay too much under this provision? Obviously, there are a couple thoughts that I had, and then I have a question. I've had a chance. I've got a wonderful company in my district, Driscoll Farms. They grow the best berries. I'm sure Wonderful or Wonderland does a good job, but great berries out of the Oxnard Plain with the folks from Driscoll. And we've met on this issue, and I am sympathetic, very much so, to the fact that although there's an argument that this has been the law for years, I think that it has been misunderstood, and I think in good faith. I don't think there was really a motive to try to deny people access to the wages that they thought the law provided. Obviously, the court case clarified that that is not the law, and these people, these hardworking farm workers and others, I understand in the trucking business and so forth, which is not where my focus has been on this because of the huge amount of agriculture in my district. That has actually been my focus. These people deserve to have that pay corrected. The idea of charging the penalties and the interest can truly put a company out of business, and I don't think that is really the intent. The intent is to pay people appropriately for their work. That being said, there are people who, and I'm a recovering lawyer, so I'll declare right up front that I find myself with the hair on my back sometimes going up when I hear that companies or individuals talk about being victimized by class actions or every lawsuit is predatory. You know, there's a purpose. There's a reason that we have lawsuits. There's a reason that we allow enforcement of rights, because the government isn't going to be able to do it all itself, and that's why we have a court system. And lawyers are the vehicle by which people's rights and wrongs are redressed. And but for lawyers being willing to take some of these cases, and they are, you know, there's no guarantee here. They take them on a contingency, like everybody else, like the CEO making $20 million a year. Lawyers want to be paid for the work they do, and if there's a threat that they aren't going to get paid or that the payout doesn't justify the risk, they're not going to do it, nor should they do it. So here, and yes, there are some lawsuits and some instances where things get out of hand, and we try to address those things here in the legislature. But to say that because a class action lawsuit has been filed, that the defendants or those being challenged are being victimized is just, to me, it just sort of defies an understanding of what this whole system was about. That being said, I heard my good friend Mr. Broad mention that the workers are here because the system hasn't been fair, that workers are not being paid for the hours of work that they put in. He also said that they've been following the rules and that the rules change retroactively, and the goal is to be fair to employers and employees. If you would substitute the word lawyer in here, I know everybody hates lawyers, but, you know, our society wouldn't exist without them. And laws that we promulgate here and pass wouldn't be enforced without them. So if we can get over that and just address the fact that the lawyers, by the way this is set up, with the current situation that says you can seek an affirmative defense, which negates effectively a year and a half's worth of work that a lot of these lawyers have been doing. Not their fault that suddenly we come in and we're going to make the law retroactive. And you know, that's very unusual for us to do that here. I know I've done a number of bills and been told they must be prospective. And in fact, we do have something called ex post facto laws, which are unconstitutional in the criminal justice system, and I suspect we have something fairly similar in the civil justice system. So we're basically saying to these people, we are going to make this law retroactive, and you aren't going to get paid for the hours you put in for the work you've done. Kind of like what we've been talking about here, trying to make the adjustments for these working people. And that everybody was following the rules, but they were changed retroactively. Well, isn't that exactly the same thing that's happening to these attorneys? So, I just think we have to be fair to everybody. This is a good, I concur that, there shouldn't be this penalty aspect that's going to put a lot of people out of business. That's not the purpose, I don't think. But we need to make those adjustments, and we need people to be paid for the work they've done. The same way, I think we cannot take care of the workers, take care of the growers, and then say to the lawyers, the heck with you. We're changing these rules retroactively, and you aren't going to get paid for the hours you've worked. Because we know that, or it's most likely, we never know, judges are all different, that you put in the time, but because this is retroactive and because affirmative defenses can be asserted and thus your claims are negated and you don't get paid for that year and a half, we're just going to let you kind of flail out there in the wind. I think if we're going to do this, I think we need to acknowledge that it's got to be fair to everybody. I know I would bet you a lot of these attorneys working with the farm workers, they hire bilingual people in their offices. They keep their offices going by what they hope is going to be a resolution, a favorable resolution on behalf of their clients. And the same, I'm sure, with the trucking industry, too. You put a lot of your own money out there, and it doesn't necessarily come back to you. And to say, well, we're going to take care of the key people here, the growers and the workers, but not the folks that enforce the laws that we require, I just think is wrong, unfair, and frankly, I really have a difficult time trying to balance what I think is a very good effort here. And I'm willing to go with what, because I understand, for every one person that likes it, there are two who don't, and vice versa, and we heard them all here today. This is not a perfect world. It's not a perfect resolution. I think it's, on balance, a good one, but why are we sort of closing out any possibility for the lawyers to be paid? Are we going to just, get rid of all the lawyers? That's what Shakespeare talked about. But you have to understand the purpose of that was not because we all hate lawyers. Lawyers are the ones that make sure that laws are enforced. And once you get rid of the lawyers, you have anarchy. And for those who hate laws and hate the state and hate government and order, that's the first thing they want to get rid of. And I know a lot of lawyers, some of them I like, some of them I don't like anybody else. But I just think in this case, there's an imbalance here. It's not right, it's not fair, and it needs to be corrected.
Thank you. Senator, we're going with, Senator Mitchell.
Thank you. So, Assemblymember Das, it appears that for language under consideration that appeases the needs and desires of the car dealers does not work for consumer attorneys and others. There are a lot of moving parts in the bill, and so my question really is to you as well as the chair in terms of process. We are clear that we are in the last second to the last week of the first year of session. And I'm, as you made the comment, Mr. Chair, I guess it was new car dealers who summarized their ask. Your comment was, we'll take the amendments on the floor. So my question is both process, what are we voting on here today? And secondly, to you, Mr. Williams, with all of this new language swirling around you, where do you stand as the bill chair? What's your position on the amendments that have been proposed? And is it your desire, which I hope it's not, to move the bill right now? Because not only is the ink wet, there's no ink on the paper on some of these issues that have been surfaced that are fundamental, as Senator Jackson just articulated, are core fundamental issues that it appears that opposition, support, and members of this committee have. So where are you, sir?
Well, it would be our intention to move it today. I will say, first of all, it is not my it is definitely not in my agenda to get rid of all the attorneys. I would not want to get rid of my senator, first of all. There's some folks back there that or the three of you. I think you are obviously presented with a quandary here. If you listen to a large portion of the opposition, this opens up the possibility of too many lawsuits. And if you listen to another portion, this forecloses the possibility of lawsuits that would gain justice for workers. So they can't both be right. I think that it would be my intention to try to make sure that we, through this legislation, do not tip the scales of justice either to guarantee attorneys' fees nor to deny attorneys' fees. And that is what I am pledged to work on. To me, that is so important that that would be a contingent upon a contingency of me being willing to work to continue the bill, not just a contingency that I guarantee to you.
So in terms of process, what does that look like? Does that?
I think there has been good work in the recent days in language, but it is literally, obviously, as you have indicated, three days of work on that language. I think that if we do not move forward, it is hard to see that we would accomplish it in the condensed time frame. But I, of course, would want language that is agreeable to the chair. And I would, of course, love any assistance from the committee staff to finish drafting that language. There have been literally 3 rounds of that language going around. On the new car dealers, frankly, I love getting credit for meeting their needs, but what they're asking for is to not qualify for the safe harbor provisions. I'm not sure that's much of a concession to anybody. It means that their folks still can get sued. I'm not sure that that's much of a concession, but if that's what makes them happy, then I'm happy to give it to them.
So the challenge about this time of year is, as we continue to talk about a work in progress, there's no language in print for us as sitting committee members to read or review. There's no mock-up. Back in my old days, we literally would on the typewriter type up mock-ups for situations like this. So there's nothing to look at. So as I continue to talk about the process, what does that mean? We are voting. You are asking that we vote today on what we've heard a variety of support if a man oppose it. It's a moving target. And so at least before we take action, someone would need to at least articulate to me what it is that's up for consideration today, and then help me understand what the process would be on the floor and all of that.
Yes. Well, we're moving our vote today was to move this bill forward. We can't amend it in our committee because of the lateness of time, but we could amend it when it gets to the floor. Some of the amendments that we've been negotiating with and been talking to the new car dealers, obviously they've come up and addressed them. We're working on that. There might be other technical amendments that we've been working with some of the other opposition, specifically like tolling time. We want to make sure that there's specific time, not endless amount of time, that the tolling would take place. So that's another one of the technical amendments that we're going to be working on today and tomorrow, and hopefully next week before we bring it up.
Okay, so before we bring it up on the floor, it will not come back before this committee.
It cannot come back down.
Okay, so some of the more global substantive issues that Mr. Williams alluded to, his desire for balance, that Senator Jackson talked about her concern about, are they on your plate for consideration, or It doesn't sound like it. You've talked specifically about the new car dealers amendments. You've talked about some technical, but that's still a very substantive policy disagreement.
Absolutely, Senator, and I would be happy to guarantee to you and to the committee to formulate language that would be agreeable to the chair on to guarantee that this law does not tip the balance on attorneys' fees. That issue is, I think, important to make sure that this does not blow up either to the left or the right, that we should not be taking an action that would either guarantee attorneys' fees or deny attorneys' fees. That should be up to the judge in the individual case to make the call.
That's will be our intention. Again, like I said, we've been meeting with the opposition, and that's our intent before it gets to the floor to make sure those amendments are in place.
Thank you.
Yes. Oh, sorry.
No, go ahead.
Oh, it's okay.
Yeah.
Okay, Mr. Vice Chair.
Thank you, Mr. Chair. I appreciate all the comments of my fellow board members. I have to admit that I was very ignorant about the way these workers are paid, and so I've had to quickly come up to speed. And so, I'm not a lawyer. Most of you know I'm in the drug business. So, so you're getting this from a...
Yeah, we might rephrase that in the future, Senator.
That's all right. That's all right. I'm proud to say I'm in the drug business. But let me just say this, that, what I like to see is a lot of consensus. And what I'm seeing here today is there's not a lot of consensus with all these agricultural groups, car dealer groups that are opposed. And I agree with the concept of a safe harbor. And I think all the employers should be included in the safe harbor provisions. I understand the issue of attorney fees, and I'm a businessman, and I take risks in business, and sometimes I win. I'm very happy to say most of the time I do, but sometimes I lose. But right now we're talking about making sure that workers are getting appropriately paid for the work that they do. So the problem with guts and amends is that, we get it at the last minute. The proponents and opponents didn't even begin to see the language until August 27th. Here we're at the last minute in our session. And I think there needs to be an opportunity for both opponents and proponents to adequately address their issues in a very professional, transparent, and appropriate way, and not to try to either delay or eliminate public scrutiny. So in its present form, I can't support the bill because I think it does pick winners and losers. I would rather take our time and get it right for the benefit of many instead of rushing to judgment, if you will, and leaving problems. AB 1513 tolls the statute of limitations. Well, that tells me that delays the amount of time that somebody could file a lawsuit, and we're adding more liability, legal liability, which is expensive liability, in perpetuity. It's going to create new liability for employers who pay employees piece rate. We heard from the car dealers that after the decision of Gonzalez that they doubled the wages and paid them even bonuses and did their best to comply with the complex labor laws that unfortunately we see in the state of California. And I'm very concerned that we, arbitrarily disqualify for safe harbor one company based on an allegation rather than a conclusion that they did in fact do something in a capricious, targeted, and unlawful way. I think the courts need to adjudicate that before we come to a decision on that. But I think anyone should be able to go into this safe harbor. And again, the bottom line is that we're going to get our employees paid for the work that they did in compliance with some very complicated laws that were misunderstood. I agree with the senator from Santa Barbara. I don't think anybody here was malicious just complying with California employment laws is complicated and it's challenging. And it's so challenging and complicated that some employers have actually thrown their hands up and have left the state, 5 million people over the past 10 years. I regret I can't support it today. I hate to see amendments coming on the floor because it doesn't give all the members an opportunity to appropriately see what's going on, and the members don't get to hear the concerns of those that are going to be wrongfully impacted by the proposed legislation.
Thank you. Senator Leno.
Thank you, Mr. Chair. I will try to add some additional thoughts to this conversation so it won't be too repetitive. As I came to committee today, I had heard some concerns from the attorneys, which Senator Jackson has addressed. What I hadn't heard, and I had an understanding that there were some proposed amendments, though clearly we're not seeing anything that satisfied the car dealers. The 4 codification pieces of the bill, I don't know that anyone opposes. They make things right for the workers who have been harmed. And I want to be very respectful of the hours that I know you have put into this, Assemblyman, and that these are complex negotiations, and a step here can unbalance things over there. So I don't want to suggest that I'm any more familiar with this than you are. I defer to you. But at the same time, you had just made a comment to Senator Mitchell with regard to your intent that attorneys not be harmed and that the courts have some discretion as to some decision making. You have seen the proposed amendment from the consumer attorneys, because I think, as I read it, it really reiterates your statement earlier to Senator Mitchell. And I wanted to see, number one, and I'll get on to some other issues, if there's any reason why we couldn't accept that amendment, which is discretionary in that it says nothing in the section precludes a judge from awarding statutory, contractual, or common fund attorney fees and costs for efforts in pursuing the action on behalf of the plaintiff until July 1st, 2016. Notwithstanding the affirmative defense herein, the employee may be considered the prevailing party on such claims for the purpose of recovery of attorney's fees and costs. So I'm not a recovering attorney because I never was one. But as I read it, that pretty much satisfies what you had said. I also, then there's the whole other issue that Mr. Turley brought up, and the suggestion that 40% of some truckers is non-productive time. I don't know how we get from 4% to 40%. That's quite a range. So I just want to make that statement without suggesting I have the solution to it. But then I also have to say that some of Mr. Brown and Mr. Belot's comments were of concern too, that there seemed to be a little lack of equitable treatment to some as to with regard to the safe harbor. So those are all of my concerns. Now, logistically, and I understand that there are many who would like to see this move quickly, this does not have an urgency clause, correct? So if this were passed and signed into law, it would take effect in January. Just an idea here, not making any suggestion or motion. But if it were a 2-year bill, to give a few more months of consideration for all these moving pieces here, with an urgency clause, the effective date really wouldn't be too much different from January 1st. So again, just an idea, because from what I'm hearing on the committee, I don't know if there is sufficient satisfaction with where we are right now. And what I am hearing is that there are many outstanding issues still there. So getting back to my multiple questions, that attorney language, does it cause problems elsewhere with your balance of coalition or your coalition balance?
There is some of that concern. we have given language back to the consumer attorneys that reads something similar, but is a little more consistent with the Senate Labor Committee analysis that we thought was excellent. It would read between lines 5 and 6 on page 10, nothing in this section shall be construed to alter any existing statutory or common law as to attorney's fees. And what I can commit to is at very least this, but with, again, the intention of not tipping the balance. I am, again, not an attorney, even a recovering attorney. So this is one of the cases where you have to kind of rely off of the expertise of some of the attorneys around you, which are diverse labor, government, and business attorneys. But I think the concern is to make sure that there is a provision that does not blow up the deal and that does not appear to one of those parties as to tipping the balance towards attorney's fees. Now, would I, my preference would be to pass the committee, to pass the bill as is, or to adopt the language that we have proposed based on the Labor Committee analysis, which I think, has some expertise behind it. That would be my preference, with the guarantee that we would continue to work on it to ensure that this language does what it is intended to do, which is to neither deny nor require attorney's fees. And, I guess the question of 4 and 40%, that's a philosophical question. I mean, often people answer that. For many workers, a bird in the hand is better than in this case, 4 in the bush or even 10. Right. And so that's a philosophical question that I think different people might have different answers to, but I think for the most part, most of these workers aren't getting any of that. So all of them getting 4% might be construed as a victory.
And that is the nature of compromise. I understand that.
Sure. I do want to say something about a 2-year bill with an urgency. I'm not sure in a compromise of this juncture you want that to happen. As soon as it's a urgency clause, then everybody walks in with their demand. And compromises of this scale are very, very easy to blow up when there's that much leverage floating out there.
One last question then, this might be for the chair of the committee. Is there anything that precludes us from having another Labor Committee hearing?
The Secretary of the Senate, and they said that we can hold it, and then we can. That's an allegation.
Could bring it back to, what do we do?
I didn't understand the answer. I'm sorry. So we could reconvene. Okay. All right. That's Senator Mitchell. It was a rhetorical question.
I have one. I don't know if I'm looking at the language.
And there's a lot of
I have language proposed by the Lawyers Association. I don't know that I have consumer attorneys. Is that what you were reading from a consumer
I
attorney's
was,
letter?
yeah.
Okay, I don't have that letter.
Suggested amendment.
Got it. That's it. This is the author's amendment.
And I will tell you that this is very confusing because there's several iterations out there. So, I will tell you that the first iteration, I think, pretty much would have blown up the deal, right? How far we can go is something that I would be willing to explore, and what I came prepared to commit to was at very least this language that was essentially drawn from your Labor Committee analysis, the consumer attorneys felt that it was insufficient to put it in the analysis or just in the public record through intent language. We are willing to put it into statute to meet that demand and need. But we want to make sure that language does not deny nor require attorney's fees, that it requires agnosticism on attorney's fees.
If I may, the language, as I understand it, originally said shall. It has been changed from shall to may, which is as neutral as you get. It says the court can if it wants to, and that's all it says.
You're speaking of the consumer attorneys.
Correct,
suggestion.
yes. They did, originally it said shall give fees, and that is in order. That is an imbalance, clearly. But when it says may, it just says to the court, you can if you want to. And that is fairly, I guess it doesn't get much more agnostic than that. It just says to the court, because this needs clarification just by virtue of how these things happen, that if an affirmative defense is asserted and prevails, then it's like you didn't bring it in the first place. So all the time and effort that went into what we're now negating. And I support that prospectively. And I support it retroactively, except to the extent that you're telling these folks we're not going to pay you for the work you've done because we're making the law retroactive. That's all. That's my concern. Other than that, I certainly share concerns that this does need some more discussion. I think it's almost there. I understand how precarious it is. But I think in terms of dealing with the attorney's fees issue, I think this is a compromise that saves that neutrality and yet doesn't punish a group because they actually were trying to enforce the law on behalf of, their clients. That's what we want lawyers to do.
Well, thank you so much. We've had a good discussion. Given the lateness of the meeting and how much we have to discuss and have to still go through, I would like to ask the committee that we hold the bill and not take a vote on it, hold the bill for next week and gives us a few more days to kind of talk about things. And we'll ask Rules to go ahead and let us hear the bill next week. That way, I think Senator Mitchell and others have brought up, they haven't seen anything. So we'll put the amendments in writing, the ones that we've already talked to, the new car dealers, and the other ones that we want to make sure we ensure that everybody's happy with, and then we'll continue to work on any other opposition if we can. I don't think we're ever going to get some people off from opposition, but we'll just do what we can.
Right, and that's not my ask.
Yeah, no, yeah, that's
my ask is just can I see it.
Yes, and we'll bring it back in writing because I think you bring a legitimate point. We do want to see it in writing, even though we can't take them here. But at least we know what we're going to be looking on the floor. It gives us guidance at least. So, with that, are we going to take a vote to hold it in committee. We don't need a vote. We don't need a vote, actually. So we don't need a vote. So we'll just go ahead and hold it in committee, and we'll see you next week.
Thank you, Mr. Chair. Senators.
Thank you.